Laura Scampion is managing partner of the New Zealand arm of global law firm DLA Piper, and she's here to talk to me for this week's Toil and Trouble. Laura, Worker Protection, Migrant and Other Employees Bill. What's this all about?
Yeah, look, it's part of a raft of legislation that's been introduced recently, or draft legislation that's been introduced recently in the sort of employment law space, as it were. Now, this legislation this bill isn't of any particular surprise to us. The exploitation of migrant workers has been a talking point in New Zealand for some time. So we were expecting, in the context, for example, of modern slavery discussions and imminent modern slavery legislation, that there would be some increased protection introduced for migrant workers, particularly now that the borders have opened up slightly. And I think the government announced another 3,000 migrant workers will be allowed back into New Zealand this week and onwards.
So this bill does sort of clamp down on a few things, including the ability of employers to provide the right documentation. So can you just give us a bit of colour around what it's actually asking from employers?
Yeah, what this legislation will allow is immigration officers and labour inspectors to go into an employer's premises and to request wage and time records and employment documentation from migrant workers, and actually ask for those to be produced within 10 days, which is very new, and it will be an offence under the legislation if that can't be produced. Now, we do know from reviews and reports that have been done in relation to migrant workers that quite often those workers don't have the relevant wage and time records nor employment agreements, which, as we know, are a requirement in New Zealand. So this is going to put increasing pressure on employers to actually have that document in place, and it gives immigration officers and labour inspectors the power to demand it in quite a quick time period.
And also the threshold to prove some wrongdoing has gone down, hasn't it, as a result of that? So not providing that documentation is as you say,
as an offence in itself, and will carry with it some fines. They're not drastic fines, they're not huge, but there will be a deterrent there for employers in terms of getting it wrong. The fines, I think, are per employee. So for those employers that have a large migrant workforce, getting it right is going to become quite important if this bill is passed.
So what it's rectifying is the fact that in the past there had to be a very high threshold for doing something wrong, wasn't there?
I think that's right. So this lowers the bar, lowers the threshold, and allows sort of increased access and right to demand documentation from employers quite quickly.
And there was something about a public register that employers will be named on. What do you think of that?
Yeah, the stand down list. Look, that already exists.
Oh, right.
So there's already a list where employers or individuals can actually be named for exploiting migrant workers, or in fact being in breach of employment legislation, and they're not allowed to take on those workers that are subject to visas for a period of time, some of which are up to 2 years. So that list is updated quite regularly and it's publicly available. Now, for employers that commit an offence under this legislation, they will also be added to that stand-down list. Now, they might not necessarily be in breach of minimum code, like the current stand-down list, but they might be in breach of this legislation or this draft bill, which will mean they'll be added to the stand-down list. So it's a name and shame document, essentially.
Right. And they also can't become directors, promoters or managers of a company if they've been named on the list?
Yeah, correct. That's new. So those individuals who do commit an offence in relation to this legislation could be banned from directorships or managing a company even. So that's quite a significant development.
Forever or just for a certain period of time?
It'll probably be for a certain period of time, but I'm not quite sure.
Yeah. That does take away people's rights in a way, doesn't it? I mean, what do you make of that?
Yeah, it's fairly draconian. Although what we do see in New Zealand is a number of individuals or small sort of SMEs becoming employers and not being familiar with minimum code or minimum rights, or alternatively deliberately exploiting an employee, a migrant employee, paying them for 45 hours a week and asking them to work 90. This is a real deterrent from doing that and from, I suppose, breaching minimum code under one entity or one employer name, ceasing that entity and opening up a different entity to employ an individual. So it could stop those practices taking place, the reinvention, as it were.
Do you see a lot of exploitation take place?
I don't personally see it, but I think we know it goes on in New Zealand. And like I said originally, I think that the driver behind modern slavery is not just about the importing of foreign goods, which is a little bit of I suppose a mistake about the misunderstanding about the direction of modern slavery. It's not just about imported goods. There is actually modern slavery, as it were, or worker exploitation taking place in New Zealand right under our noses.
Mm. The context to this, of course, is that employers are crying out for migrant workers and they're not coming through the border in the numbers that they need. What do you make of sort of clamping down on employers when they have this issue trying to get people anyhow?
Yeah, it's the double-edged sword, isn't it? So employers desperately need more workers, particularly after the borders being closed during the pandemic. The borders are now slightly opening again, allowing some migrant workers to come in. But the other side for employers is that it could be a deterrent, this bill, in terms of it's just too hard to take on more migrant workers because of the potential infringements and offences and the rights of the labour inspector and the immigration officers to come in and demand that documents are produced.
Do you think it is too onerous to hire migrant workers? You know, if you're keeping up to date with the paperwork, is it an onerous task?
No, I don't think it is. No.
Right. Do you ideally need help with it from an employment specialist?
Yes, ideally. There's a lot available that's online now through the New Zealand Government and MB and so on that can help employers build an employment agreement, that can alert employees to what minimum code is. Some of this legislation is also about educating the migrant worker, and I think there's going to be community projects that are rolled out as part of this bill to educate the migrant worker as to what their rights are. So knowing your rights is such an important part of this equation. It's not just the employer knowing how to build an employment agreement and what the minimum wage is. It's also those migrant workers coming in knowing that they have minimum rights in New Zealand.
That's right. Now, let's talk about the restraint of trade issue. Now, tell us about this new bill, or it's been amended. The bill's been amended?
Yeah, it is a new bill.
It's a new bill.
And it is actually new legislation fixing a problem that, from the perspective of an employment lawyer, we didn't think we had. So this is a new piece of legislation that's really codifying the fairness or reasonableness or use of restraints of trade. Now, in New Zealand, restraints of trade are relatively common. So we look at loads of employment agreements that have a clause in them that say after you leave us, you can't go and work for a competitor for 3 months or 6 months, or you can't take our clients or attempt to solicit our clients or our staff for a period of 3, 6, 9 months and so on. But there is nothing in legislation that sets out the area in which they can operate, for example, the whole of Auckland or New Zealand, and there's nothing that sets out what period of time is reasonable, 3, 6 or 9 months. Now, this legislation is aiming to, I suppose, codify reasonableness that the courts are generally issue their opinions on or their judgments on in this area. What it actually says is that restraints of trade will be ineffective for those employees who earn less than 3 times the minimum wage. So it's really aiming to protect those employees who earn round about 100 and 120k and less from being restrained from going and working for a competitor. It also says that if you do have a restraint, you have to pay for it. So you have to pay for each week you restrain the employee after their employment's ended at half their salary. It also says that any restraint can't be for longer than 6 months. Now, for really senior employees in New Zealand, we quite often see restraints for longer than 6 months because those restraints protect the legitimate proprietary interests of the employer. That senior employee might have had very good access to the employer's database of clients, customers. It may have influence, indeed, over the organisation's success in relation to its clients and customers. So 6 months does seem a little light for your most senior executive.
Do you think lawmakers believe that employers have been taking the mickey in their restraint of trades? Because that's what it suggests, that, you know, it's a loosey-goosey Wild West scenario. Yeah,
potentially, but it's part of a raft of sort of draft legislation that we've seen introduced recently aimed at protecting the employee in New Zealand. And, you know, we've just spoken about the exploitation of migrant workers. This is another one. So, yes, lawmakers might think that employers are imposing restraints where they shouldn't. It's not something that I see all the time. Restraints that are imposed on very junior employees or employees on very low salaries are generally not enforceable, and most employers won't endeavour to enforce them unless they are imposed on someone with a high salary or doing a very senior level of job.
The clause in here that suggests employers have to pay their employees part-time for the length of the restraint, that's Do you think employers realise that's in that law? I've never seen that.
They might not. It's a wee bit draconian. And what we see with quite senior employees is that a salary will have built into it for a senior person, an amount that might reflect how long they'll be restrained for after their employment. There's nothing scientific about it, but it might be slightly beefed up in order to acknowledge the fact that that employee won't be able to go off and work for a competitor for 3 or 6 months. But actually having a calculation that says after your employment you'll be paid each week that you're restrained is quite new and something that I haven't seen spoken about before in this context.
Absolutely not. That's a bit of a that's a bit of a shocker. That's great. Thank you very much, Laura.
My pleasure.